I'm a big fan of efficiency. I'll be honest. I like to carpool. I like to combine things. I like judicial economy where we can, but not at the expense of a fair trial.
And thank you. And just want to say good morning to everyone. And let's go ahead and set forth our for the record. And that would be in Hunter Brown versus Affinity Lifestyles matter. And we'll start first with the plaintiff, then we'll move to the defense.
I'm Will Kemp, the plaintiff.
Your Honor, this is Teddy Parker, also on behalf of the plaintiff. Plaintiffs.
And we'll move to the defense.
Good morning, Your Honor. Cindie Hernandez on behalf of Winco Foods in the Daisy Wynn complaint.
Good morning.
Good morning, Your Honor.
Colt Dodrill, bar 9000, counsel for Nevada Beverage.
Good morning, sir.
Good morning, Your Honor. Jim Kavanaugh with Gordon Reese for Real Water of Tennessee.
Good morning, sir.
Morning.
Good morning, Your Honor. Chad Fears on behalf of Hanna Instruments, SID US International, and Scientific Instruments Development International, Inc.
And good morning to you, sir.
Good morning, Your Honor. Dallin Connect with Bacchus Burden on behalf of Sprouts and Albertsons in the Brown Real Water Matters and Sprouts in the Henry Real Water Matter.
All right. Good morning, sir.
Good morning, Your Honor. Daniela LaBounty on behalf of defendant Costco in the Henry and Way matters.
And good morning.
And
good morning, Your Honor. Dawn Davis for Milwaukee Instruments.
Good morning.
Good morning, Your Honor. Kimberly Nelson, bar number 15295, counsel for Terrible Herbs in the Henry matter.
And good morning, ma'am.
Good morning, Your Honor. Robyn MacGuire, also on behalf of Costco Wholesale Corp in the Henry and Way matters.
And good morning.
Good morning. Lorene Frister on behalf of KE Distributors in the Brown and Henry matters.
Okay.
And good morning, Your Honor. Jim Neal on behalf of UNFW and Whole Foods Market in the Brown, Way, and Henry matters.
And good morning, Mr. Neal. Good to hear from you, sir.
Good morning, Your Honor. Taylor Martinez on behalf of Affinity Lifestyles, Inc., DBA Real Water.
And good morning.
Good morning, Your Honor. Caitlin Zapp for KE Distributors of Nevada in the Henry and Brown cases.
All right. Good morning. And does that cover all appearances? Just want to make sure we didn't overlook anyone. All right. Anyway, it's my understanding we have plaintiff's motion for consolidation. Is that correct, Mr. Kemp?
Yes, Your Honor.
Okay, you have the floor, sir.
Your Honor, this is our motion to consolidate. The Brown case has 6 plaintiffs. The Henry case has 5. The Lee case has 4. So what we're proposing to do is put them all in one case. We spent 10 pages in the motion, 8 pages in the reply, explaining why. I think Mr. O'Doon, in his joinder to our motion, managed to characterize it in 2 magic words, which is judicial economy. And it just makes more sense to try this case one more time as opposed to these other 3 more times. So these cases are kind of unique in a way because common cause, pretty much the same injury. Your Honor had the benefit of hearing the 7 plaintiff Gallagher case, so Your Honor knows the evidence, and the causation is exactly the same for all of them. The injuries are pretty much exactly the same. You know, they drink the water, there's really no treatment for acute liver failure unless you have a liver transplant, which Mr. Henry did in this case. But the others, they go to the hospital, they drink good hospital water, they stay there to work for 5 to 8 days, and they're discharged. So it's pretty much the exact same case Your Honor tried in Gallagher, with the exception in Gallagher we had a death. In this case we had a liver transplant. So their first argument is, oh, some of these are different times. In other words, some people bought the water in 2018, some bought it in 19, some bought it in 20. Well, I point out we had the exact same situation in Gallagher. We had 2018 people, 2019, and 2020. Really doesn't make any difference because the undisputed evidence is that there's no difference in the manufacturing process during these time periods. They're using the same titanium tubes, they're using the same employees, same formula, same secret room where they're mixing the concentrate. So that's really not a difference, Your Honor. And for those reasons, we just think it makes a lot of sense to consolidate the cases. And each trial takes 5 weeks, as Your Honor knows from the Gallagher case. It just doesn't make any sense doing 3 trials of 654. We can do 1 trial of all 15 people. And really, they really don't make any argument whatsoever that, you know, some of the distributors say, well, we're only a distributor in one case and not another. You know, they're distributors. They have derivative liability. They sold the product, it's defective, they're liable. So the fact we have 1 distributor, 2 distributors, or 40 distributors, I don't think really impacts the length of the trial, because even if we were just doing real water, we'd have to present the testimony that they bought the product and consumed it. Your Honor, and for those reasons, we would submit that the motion should be granted.
Mr. Parker, is there anything else you wanted to add, sir?
Good morning again, Your Honor. Teddy Parker on behalf of the plaintiff. I think Mr. Kemp perfectly presented the motion, Your Honor. I have nothing to add.
All right, and as far as, just want to make sure I get this correct. As far as Affinity Lifestyles, I think that's Mr. O'Dou's client, is that correct?
Yes, Your Honor. I am appearing on behalf of Mr. O'Dou for Real Water, and we have nothing
I
more.
understand that, ma'am. I just wanted to make sure I didn't overlook you. You have the full...
Yes, you're correct, Honor.
Yes. Anything you
And
want
we
to
have
add?
nothing further on behalf of Real Water.
Okay, we'll hear from the oppositions.
Good morning, Your Honor. Colt Dodrill, Bar 9000, Counsel for Nevada Beverage.
Okay, sir.
I'm a big fan of efficiency. I'll be honest. I like to carpool. I like to combine things. I like judicial economy where we can, but not at the expense of a fair trial. And the concern here is that this is just too much. And I know the Gallagher trial is not part of the record in this case, but Your Honor's familiar with it. Most of us here watched it. Some of us lived it. And there were some things that were missing from the Gallagher trial, and that was retailers and distributors. And in this case, we're going to add 9 parties that weren't in the Gallagher trial. And those parties are going to get an opportunity to conduct voir dire, opening statements, cross-examination of experts and other witnesses, and make closing. And I think to find a fair and impartial jury consisting of a panel of folks that won't be hard-shipped by sitting here for 2 to 3 months is going to be a lot different. We're going to need a larger pool. We'll probably have 2.5 weeks of voir dire, maybe 1.5 weeks of opening. And it's very possible, based on all the parties here that are involved in the various cases.
I have a question for you, sir, because I've had multiple cases where that exact thing has happened. And that wouldn't be the basis for not consolidating. I want to talk about common questions of law and fact and all those types of things I have to look at. Because when it comes to trial, it's not a question of convenience. Heck, if that was the case, I would never have cases involving multiple parties and or class actions and the like, because I've had some fairly complex cases in this department where that exact scenario has occurred on multiple occasions. But we've had 3 weeks of voir dire, and we've had many parties involved in the case, you know, whether it was class action, and in those cases, we actually had subclasses go to trial. And so I want to focus on the rule and why I should not consolidate.
Sure, Your Honor, and I'm happy to address that. And part of that is the distinction on these cases, and counsel mentioned that briefly in his argument, which is not all of the defendants here are being sued by all the plaintiffs. Some defendants, retailers and distributors, are only being sued by one of the plaintiffs. So in the cases that Your Honor describes, it's typically a big case, and there's a central party, and solely a central party. And if Real Water was the only defendant, maybe it would make sense. But that's not the case here.
But I will tell you this is factually, and I understand your perspective, but I've had cases just the opposite of what you're describing. I've had cases go to trial where we've had, from a class action perspective, 20 plumbing companies come in, right? They're part of the case, and we've had all the complexities you're talking about. Nonetheless, we were able to very efficiently try those cases, right? I mean, I've had that, you know, and so I'm trying to, I mean, I understand complex civil litigation. I do. I understand everybody has due process rights. I get that. Everybody has a right to cross-examination. Everyone has a right on behalf of their client to conduct a meaningful voir dire. And I've never prevented someone from doing that. And just as important too, that's one of the things we typically have done in this department, because I've had 6-month trials. And we do the appropriate screening from a jury perspective, and that's why we do, we have the jury questionnaires, and I look at the jury questionnaires, and I know lawyers sometimes argue, Judge, it'll save time. It never saves time. But it sure does help from a jury qualification perspective when it comes to time issues and hardships. That's kind of how I look at it, you know? So let's focus on the rule. That's what I want to do.
Well, I understand that, Your Honor, and one of our concerns was timing, and the timing of filing a motion to consolidate after inconsistent dispositive motion rulings by the various departments. For example, NSF's motion to dismiss, and NSF's not a party in Brown, but NSF's motion to dismiss and waive was granted. NSF's motion to dismiss in Henry was not. And I think if they wanted to consolidate these cases and proceed as Your Honor had indicated, it has done in other cases, then the appropriate timing would have been prior to those motions. Some of these cases have been pending almost 3 years. Well, why now? It just raises a number of questions, and we think these cases would be more efficiently adjudicated as originally filed.
Okay, sir, I understand. Anything else?
I don't have anything else, Your Honor. Thank you.
And you're welcome, sir. And we'll hear from the next opposition. You can go ahead and identify yourself and who you represent.
If nobody else will stand up, Your Honor, my name is Cindie Hernandez. Again, I represent Winco in the Way matter.
Good morning, ma'am, and you know all about those complex cases.
I do. I've been a part of them, as well as my former partner, David Lee. And
absolutely.
Been in with Mr. Parker. So I appreciate the court's perspective and the court's willingness to hear my argument. Your Honor, to turn to the rule under Rule 42, this isn't just a joinder for potentially common law or common facts. The court can consider joining these cases for a variety of reasons, for trial purposes, as well as judicial economy. And that's what I want to talk to the court about here momentarily, is unnecessary cost and delay. Mr. Dodrill brought up to the court's attention NSF's motion to dismiss before Judge Johnson. That's where the Way case is currently postured. And that's where Winco accepted the assignment to Judge Johnson nearly 2 years ago as its trial judge. But the interesting thing about Way that probably should have been brought to the court's attention both by the plaintiffs and the defendants is that the plaintiffs pursued an appeal in Way that's still open under number 87514. And looking at the docketing statement for that particular appeal, looks like the last entry was in December of 2023 with an assigned settlement conference in January of 24. I spoke with NSF's counsel, or one of them, Mr. Fountain, before today's hearing just to get an update on status. And I don't believe that conference went forward, although I do understand the parties are talking. I'm not professing to say that Winco has any skin in that game, Your Honor, but typically what happens is once the notice of appeal is filed, that puts a stay into place for the case. And what I also did in preparation for today's hearing is go back and look at Judge Johnson's docket 4-way. And besides that dispositive motion, what's happened in that case, frankly, Your Honor, is nothing. What happened by virtue of stipulation under a 54B certification was an invitation to the Nevada Supreme Court to hear on an expedited basis whether NSF was correct or incorrect. And the genesis of its motion, and if I'm characterizing it wrong, I'm hopeful somebody's on the line to fix me, but it was all about whether NSF owed the plaintiffs in Way a duty of care. Judge Johnson said no, and she said no again on a motion for reconsideration, and now it's up on appeal. It's still open matter. So as a jurisdictional matter, Your Honor, I'm not sure that this court has the ability to consolidate Way until that matter is handed back down to the court. And I've given a lot of thought about what happened in our construction defect cases when we didn't really know if a stay was imposed or not. And sometimes that happened by a formal motion to the court, sometimes agreement by counsel. But we typically saw it come up when we had carrier insolvency.
Right.
And the only one that came to mind immediately was Legion, and I'm sure there are a host of others. But what would happen is for the impacted party, whether it was a general, developer, or sub, is that we'd have to file a notice of suggestion, and then either through a subsequent stipulation or a motion before the court, we had to figure out if that stay or bankruptcy notice applied to just that party or the entire case, meaning the court made a determination or counsel made a determination if the case was going forward as a whole or if it would be parsed out or not at all. And so by virtue of looking at Judge Johnson's document, as well as the stipulation entered into that court on December 8th, that stip unfortunately is silent, but I do think that the lack of activity in that case speaks volumes, not only from Judge Johnson's perspective, and again, I'm not so sure that she has jurisdiction, or this court has jurisdiction to entertain the consolidation of Way, but that aside, Special Master Hale, who's been effectively presiding over all these matters, has not entered a case management order for Way. And I think that matters here from a procedural standpoint because Brown and Henry are miles ahead of Way. And I've been doing this a long time. I'm a quick study. I can read, and I've been reading as much as I can, as fast as I can. But for purposes of jurisdictional considerations, I just don't think this court can move forward as to Way. Winco's not a party to Brown and Henry, so I'll have to defer to the court and the party's argument on that. But as it relates to Way, I just don't think we can go forward. Again, I recognize that that's not in the defendant's arguments, it's not in the plaintiff's, but I do think as an officer of the court, I had to bring that to your attention. Thank you, Your Honor.
You're welcome,
Yeah, Judge, I'm kind of surprised to hear this argument because it wasn't made in the pleas, as counsel just noted, so I don't think it should be considered. I think, however, though, that there was a 54B certification in the Way case, and I think there had to be or there wouldn't have been an appeal. NSF hasn't filed an opposition to this. I don't see any reason why Winco should be able to make arguments on their behalf, which apparently they want to do. And the basic argument appears to be we have to wait for the Nevada Supreme Court to hear the appeal on Way before Winco can be tried. I don't see any basis whatsoever for that. And this is, I think there is 54B certification. I'm trying to confirm that with Mr. Pepperman right now because this, like I said before, this is a brand new argument that wasn't raised in the briefs, Your Honor.
Here's the certificate I
But go for it, B, yeah. But and so let me go to the other arguments. Nevada Beverage Way raises a procedural argument. They say we should have filed a motion to consolidate before motions to dismiss were filed. Well, we can't do that, John. We have to wait until after there's an answer filed to file a motion to consolidate. So procedurally, we did what we had to do, and that argument I don't think is appropriate. Then they're arguing, oh, there's just too many people in this case, 10 distributors. In a typical, not even a big construction defect case, a typical construction defect case, you have more defendants than that. As the court mentioned, you have dozens of subcontractors, 20 plumbing companies. I think that was the Kitex case. Mr. Pepperman has confirmed that there was in fact a 54B filed in the Way case, so that's not an issue. And with regards to Way, one interesting fact about the Way case that counsel neglected to mention is that Way was the subject of a published article finding causation, a peer-reviewed article saying that there's causation. So I don't know what counsel thinks her defense is going to be in the Way case, other than usage, but there is a peer-reviewed article on causation with regards to that case. And you know, for those reasons, Your Honor, I don't think someone should be allowed to come in here at the last minute and make a brand new argument. And then I also don't think someone should be allowed to argue on behalf of another defendant, NSF, who hasn't even opposed this motion. And for those reasons, we think the motion to consolidate should be granted for all the cases, including but not limited to Way.
And when you
I
say
would also point out that if counsel feels later on before the trial that she hasn't had a full and complete opportunity to conduct discovery to her satisfaction, she has the remedy to file a motion for severance before the trial.
I understand.
Randy Wren is the plaintiff asserting claims against Winco. It's not his name. Thank you.
And for the record, how many other row water cases do I have? I'm looking here, it appears to be another 5.
Your Honor, this is Chad Fears for Hannah, and I wanted to raise this. It could go to the prejudice to the defendants, but it's going to be more of a housekeeping. You do have 3 cases on your February 10th, 2025 stack. Brown is one of them, of which now Mr. Kemp wants to consolidate 2 more cases. We had on that stack, we have 28 plaintiffs, which, hey, that's fine. That happens. My concern, especially if you do grant this consolidation, is we're going to have some relief because initial experts are due June 11th. And just looking at 28 plaintiffs, and we usually want to take the plaintiff depositions and treaters before disclosing experts. And I'm taking some really very conservative numbers. If we have 28 plaintiffs and assume 1.25 deposition per plaintiff, because some have spouses, some are minors, they'll have both parents deposed. And that would be 35 depositions. Treaters, say 1.5 treating physicians per plaintiff. Some will have 1, some will have 2, would be 42. We really need to do 77 depositions before June 11th. And we have a trial set for currently May 20th. Their plaintiff has filed a motion to move that to 5/28. No one has opposed it. We are currently in the next 11 days trying to take 27 depositions in the Wren case. And so I raise that, Your Honor, that if you are inclined to grant this consolidation, we're going to need relief on that scheduling order. It's going to be very difficult to comply with all these cases that are on your February 10th, 2025 stack.
And is neutral Floyd Hale, is he managing all these cases?
Yes, Your Honor. And I don't understand counsel's first point, because this case that we're consolidating into set down for trial in September of 2024. So I don't know why he thinks that these cases on the February 25 stack are such a big problem. But if they are, we can bring this to Special Master's Floyd Hale's attention. And as counsel knows, we've been pretty accommodating on seeking relief. But the stack this would move to would be this
February, right?
No, this moves to the September 8th trial stack room. Well, I think it's September 8th, it's sometime after.
Is it, check it out and see.
February 2025.
So the controlling case, isn't it set for trial in February? No.
That was my understanding.
And the Brown, Your Honor, this is Chad Fears. The Brown case is set on the February 10th, 2025 stack with initial expert disclosures June 11th, 2024. And like Mr. Kemp has said, he's been accommodating and moving stuff. I just want to have that on the record of we now with the other, we will have now 5 real water cases in front of you. If you consolidate the Henry and the Way case into Brown on the February 10th, 2025 stack with 28 plaintiffs. And so while
Yeah,
that's
not the intent here, Your Honor. The intent is to try these 15 cases on the September stack and leave those other two on the February stack for the precise reason counsel believes so.
Well, the question is, how realistic can we trial these cases on the September stack?
I think it's very realistic, Your Honor. It's March now.
So that's. Yeah, so I look here and we have Hunter Brown is the controlling case here, right?
It's the oldest, as I understand it.
Right. And that's currently, so these would be consolidated under Hunter Brown,
He's the lead case, Your Honor.
right? But Hunter Brown set for February. Am I missing something?
Well, Your Honor, the first thing we're missing is that all three of these cases have people over 70. So
Yeah.
we can file a motion to rectify trial date anytime we want, which we will if there's a dispute over trial date. But
Well,
I think
the
we're
thing about it is-
getting away from the big issue here, which is consolidation.
Well, I understand that, and part of consolidation is case management.
Right.
Because at the end of the day, I don't mind saying this, when it comes to this specific case, I'm going to have to, if I do grant consolidation, then I have to manage this case. I just do. And the number of parties and the number of potential defenses and the complexity of the case being products liability and distributor liability and all those things, that doesn't really concern me. What concerns me is this: if I consolidate, when do we go to trial? And just as important too, that it's fair to everyone. That's all. You know, that's simple of an issue. Interesting. And yeah, Mr. Kemp, there's no question you can file a motion for preferential trial setting. I deal with that all the time. But what I try to do is this: that if I grant that type of motion, I just want to make sure it doesn't circumvent parties' due process rights, because we have competing interests there. You're 70 years old statutorily, you're given preference. I get that, you know. And but anything else I need to know as far as this is concerned in this record?
No, Your Honor. I would point out that the liability discovery hasn't been done. We've tried the case twice already.
Go ahead, ma'am.
This is Cindie Hernandez again on behalf of Winco. I think Winco is situated much differently than a lot of the other defendants. Your Honor, there was a lot of generic expert deposition testimony taken well before Winco was made a party to the case. And in fact, on March 28th, this is one of the hot topic issues in front of Special Master Hale, is whether those depositions can be reopened for people who, after reading the transcripts and establishing good cause, can proceed with those depositions. And the plaintiffs have earnestly opposed the defendant's ability to do that. And so when we're talking about case management and fairness, Winco is incredibly behind a lot of the other defendants who have not been a part of these trials. And Henry is currently postured before Judge Kishner, and she just entertained the Hunfordson matter. There's no reason that Judge Johnson still couldn't entertain the Way matter in a fair fashion. But Way was a 22 filing. Brown and Henry were 21s. And again, Your Honors, it specifically relates to Winco. I'm going to have to file, subject to what Special Master Hale agrees to in the Special Master hearing a couple of weeks from now, is how many discovery rights do I have short of doing a deposition on the stand? And I don't submit that's fair, Your Honor. And if this court has seen anything about fairness and unfairness, then I would encourage you to recall what happened to Hannah in Milwaukee in the Gallagher trial. They were putting on an expedited trial. Mistakes were made, sanctions were imposed that had a direct relationship to the verdict coming out of those cases. And that's exactly what Winco has a right to avoid under a fair management approach for purposes of Rule 42(1). Thank you, Your Honor.
Yeah, without going into detail and the sanctions that were involved in that case, but ultimately it focused on the fact that there was testing done that wasn't disclosed.
Well, absolutely, but it was a very abbreviated discovery schedule, is my point.
But this is important too, when we look at it from a discovery perspective. It's my understanding, and I would anticipate it's true in these cases also, that Affinity Lifestyles has admitted liability, right? Manufactured.
They've joined in this motion, Your Honor.
Well, that's my point too, but I mean, I'm going back to, number one, they've admitted responsibility.
In the first two cases they have, and we expect that to happen in the third case.
But those admissions happen after a ton of discovery and expenses have been run up. We all know how this book ends. It's a matter of when Real Water makes that admission.
But they make
this is the silliest argument I've ever heard. She has one plaintiff, and she's telling the court that she cannot do one plaintiff's deposition and one treater's deposition by September. One plaintiff's deposition and one treater's deposition by September.
No, Your Honor, the fact sheet from Ms. Wren indicates that it was not only Winco, but other identified purchases that she had made. Absolutely, I can take a deposition of treaters. Absolutely, I can take a deposition of Ms. Wren herself, and I intend to do so when jurisdiction is established back in Judge Johnson's court, pending this court's decision on the motion before it.
Okay, but and it's my recollection as far as the types of evidence that has been produced. And remember, we had multi-plaintiffs go to trial in the prior matter as far as this case is concerned. And so when it came to medical causation, it appeared to me that was fairly straightforward, right? Exposure, expert testimony that hydrogen causes liver problems, and that's pretty much the case. And there might be, I mean, I don't know anything about the plaintiff in that case. I guess it would be is it Wren or Wynn plaintiff? Then there's issues as to the severity of injury caused by the exposure. And so from a medical causation perspective, it's my recollection that the case was fairly straightforward. I understand there was a lot of issues raised. They ultimately resolved as a result of a law and motion practice. And those decisions I had to resolve really focused on medical causation issues under Morsicado, under Williams, under what's the one after that? But you know, the litany of cases, Hallmark, of course. But and that was a fairly straightforward analysis, right? That's my recollection.
Your Honor, this is Teddy Parker. If I could.
Yes, sir.
Just to correct something that Ms. Hernandez said, and she didn't sit through, maybe she read the transcript, but she didn't sit through the Gallagher case. And I don't believe she sat through the Hunt-Watson case. But in terms of Gallagher, the mistakes that Hannah and or Milwaukee made had nothing to do with the timing of discovery. The actual failure to disclose testing was testing done by someone who had passed away before, and that had nothing to do with the timing requirements and getting that case prepared for trial. The other testing was asked about in the form of written discovery, request for production of documents and interrogatories. And not only did they fail to produce the testing, they failed to even identify the person who performed the testing. Again, that had nothing to do with the timing, dates and deadlines in that Gallagher case. In terms of the Hunt-Watson case, there was a distributor in that case. Terribles was a distributor, or a seller, I should say, of the product. And in both Gallagher and in Hunt-Watson, ultimately all of the defendants that went to trial stipulated to the amount of the medical bills. Your Honor, the plaintiff's time on the stand was a small portion of the trial. And as the court recalls, it was mostly expert-driven liability discussions. And Real Water did concede not only liability, but causation in both Hunt-Watson trial and the Gallagher trial. And so I struggle to see why, given what the court knows about this case and given the briefing, why these cases should not be consolidated. Your Honor had the pleasure, I'm using pleasure pejoratively in part, of trying a 5-month trial with thousands of homes, thousands of potential homeowners, and you were able to manage that case. There's
actually 30,000 homes.
Thank you. There's no doubt in my mind that you can handle a case with 15 plaintiffs or however many plaintiffs we're looking at now. I have no doubt. And I think Ms. Hernandez has no doubt that you can manage this case. And I don't think there's a defendant here who believes that you cannot manage this case. You are adeptly able to manage this case. And so the briefing did not include some of these arguments that have been made today by the defendants. I don't think they should be truly considered, but I know your honor, and you have a habit of considering all sides, regardless of when they're presented. And I think that Mr. Kemp has appropriately pointed out what the typically the criteria is for granting this motion. I think we meet it, Your Honor. And you made point of something that's very important. Mr. Hale can work with the parties to determine discovery dates and deadlines, and that can be brought back to the court to determine what flexibility is required to address preparing for trial. That's all. Thank you, Your Honor.
You're welcome, Mr. Parkin. Mr. Kemp.
Your Honor.
Yes, somebody else wanted to join in, and
Yeah.
please identify yourself so we have a.
It is just Chad Fears. And just for point of clarification, in their motion, page 4, in their declaration, paragraph 6, they say, if this motion is granted, the discovery deadlines in Henry will be continued to match the scheduling order in Brown. So I know there's been talk about a September trial, but in their own motion, they asked to go with the Brown scheduling order. And I just rest on my arguments of why that it's going to be difficult given the trial we have in Wren Carrier and the Kava case at the end of May to get everything done to get to the expert deadlines.
Because the case, the Brown case is set for trial once again in February, right?
Yeah, February 2025.
Right, okay, I understand that. And we have no rule on the case is set in September, right?
Correct.
Okay, and I just want to tell everybody this, and I kind of look at it from this perspective because we have a lot of cases, right, in this department. Every department does, but we're also a business court department too. And so, for example, in September, I don't know what's on my calendar because I don't mind saying this. I go day to day. I just kind of look at what's on my calendar for tomorrow. I'm not a lawyer anymore, although I understand and have empathy with lawyers because you're looking at your calendar from not just what's on your calendar for tomorrow. You're looking at next week, next month. You're looking at 6 months from now and a year or two down the road. I don't do that. I kind of look at what's on my next stack and what I have to deal with tomorrow, but we do have long-term planning. And so currently I don't have this matter on a trial stack in September, correct? In this department. My case in this department is set for February, right? And so that's kind of my point here because I don't know what's on my September trial stack. For example, we have other cases with firm trial settings. I don't know. I don't even know the availability of September. I don't know. And just as important too, what I tend to do with cases of this nature, I do try to do long-term planning because what happens, I'll give you a perfect example of this number of parties. If we started a trial late September, will we even get done before the end of the year? I don't know. And I worry about losing jurors, during the holiday season and all those things. And that's why, I don't mind saying this, when it comes to larger cases, I tend to, with a lot of parties, I try to do that in a time period where there's not much holiday issues. We can get things done, we can go for an extended period of time. And just as important, we time qualify appropriately all of the jurors. And that's one thing I've always done. But anyway, this is what I'm going to do. And I don't mind saying it. How many other, I have another 4 or 5 of these cases on my staff.
5 total.
5. Should I be predisposed to put them all in one case?
Your Honor, I apologize. I don't mean to interrupt, but this is Robyn MacGuire on behalf of Costco Wholesale. I was just waiting for an opportunity to get in before you make your ruling. May I be heard?
Absolutely, ma'am. I've never said no.
Thank you very much. I appreciate it. I just want to address one issue that I think hasn't been brought up. We've been talking a lot about scheduling and efficiency, judicial economy, and Your Honor brought up earlier common issues of law and fact. And I think there is an assumption here that medical causation is going to be straightforward. It's going to be similar for the various plaintiffs. And at least on behalf of Costco, we do not believe that is accurate. All of these plaintiffs have different medical histories. Different facts are at issue. different potential alternative causations, different consumption and purchasing information, timing of consumption, damages. My client is only in 2 of these cases and not the other 13 cases. And it's extremely prejudicial, obviously, to have all of these plaintiffs consolidated in one trial. I have no doubt that Your Honor can handle and manage the efficiency of the trial, but we haven't spoken about the jury. And I think it's going to be extremely difficult for the jurors to keep track of all of these different plaintiffs and potential alternative causes of the plaintiff's damages. And, you know, at the end of the day, I understand
what would be those potential alternative causations you're talking about that would be mandated under Williams as independent alternative causes?
Well, to the extent that the plaintiffs had other risk factors or other potential causes for
Wait. Risk factors are not alternative causation. They're just risk factors.
Well, Your Honor,
I've dealt with that for years. As far as risk factors, I've had that come up. That's not medical causation. That's not Morsicato. That's not exercising medical judgment. That's not Williams. That's not Hallmark. I mean, I get that. I mean, I don't mind. 2 of the I guess seminal medical causation cases were in my department.
Yeah, and I don't dispute that, Your Honor, but I will say that each case stands on its own, and I believe that there are potential alternative causes for liver injuries that have nothing to do with real water, and we have, and should have an opportunity to present those defenses. It's not as straightforward, I believe, as the plaintiffs are making it seem, and particularly for my client that's only in 2 cases to be consolidated with 13 other plaintiffs. It obviously magnifies the damages. It magnifies the verdicts in these cases, and it's extremely prejudicial.
But we haven't identified those potential independent alternative causation theories for me to consider.
Well, I'm not prepared, Your Honor, today to go into that. I didn't realize that we were going to be getting into the specific facts of alternative causation for each plaintiff. I'm sure we can present you with that information if it's necessary, but I think that it is something that the court needs to consider.
Your Honor, we can only go by history. In the Gallagher case, we had 7 plaintiffs. 5 of them, there was no alternative causation argument made whatsoever. 2 of them, Mr. Haley and Mr. Belsky, they argued turmeric and kratom, and the judge strict them because that didn't comply with Williams. So ultimately, when the case was tried, there's no alternative causation presented whatsoever. Moving to Hernandez, 5 plaintiffs. There was an alternative causation theory presented with regards to Mr. Hernandez. That was stricken for noncompliance with Williams by Judge Kishner. So there's no alternative causation argument made in that case either. So history tells us that this alternative causation argument, may sound good, but it really doesn't bear out because all these people drank rocket fuel, and the defendant's going to stand up and say, oh, their great uncle got liver failure, so there's hereditary. That doesn't bear out, Your Honor. So I don't think this alternative causation thing has any merit. But if it does, if counsel thinks that for some reason or other there's going to be a 3-month alternative causation trial on one specific plaintiff, they can file a motion for severance.
Ma'am, is there anything else you want to add? Because I don't want to overlook you. I want to make sure you've expressed your concerns.
Thank you. I think at this point it's premature to make that determination that there's going to be no alternative causation. Obviously, we need to finish discovery. We need to look into the case. The experts need an opportunity to weigh in on that. So I don't think that, it really is fair at this point to determine that there's going to be no alternative causation for 15 different plaintiffs. I understand the plaintiff's argument here and why they want to consolidate, but I just don't think that that's a relevant argument at this point in time. I think that we should have an opportunity to present a defense.
All right, and I will say this, 2 points. Number 1, I've never prevented a party from presenting a defense assuming it's based upon sound medical science that has been tested and peer reviewed, right? And we understand that, and that's one of the mandates in Hallmark, right? But you don't get a chance, and just as important too, if that independent alternative causation is going to be presented, there has to be a foundation for it too. And so I don't mind saying this, and we can attack that head on, but I can't, but I'm looking at it with this lens. Are there common questions of law or fact? Everything doesn't have to be identical. if that's the case, then how many cases are there right now?
Total?
This claims, I should say claims that would be in front of me.
Okay, specific plaintiffs?
Yes.
There's 15 in these 3 cases.
Because if that was the case, then I'd have to deal with 15 separate trials.
Right.
And that's kind of my point, right? And I don't mind saying this. I mean, we've navigated in this department a lot of complex legal issues over the years, and some of them dealt with healthcare issues. Some of the cases involving hepatitis C, we had the issues, and that was a fairly complex case. In fact, that was the largest Hep C outbreak, I think, in the history of the country. And that dealt with a lot of plaintiffs. Just as important too, we had 30,000 claims made regarding defective plumbing. And Ms. Hernandez probably remembers this better than I do. I don't know how many plumbers were involved in that, man. Was it 20, 30, 40, 50? It was a lot, right? It was a lot. And so that's like 20, 30, 40 different distributors in a way. But we dealt with that, right? And just as important, I think the best way we dealt with that, and you remember this, Mr. Hernandez, we ended up having some classes going to trial, you know, but at the end of the day, all those cases were managed. And I think I had that case on my docket longer than any other case. I think I had that case for 8 or 9 years. Total, including the repair protocol that was put in place.
Right.
But that's a long time. But this is what I'm going to do. And I'm looking at this through this lens. Does it meet the requirement of the board? Yes, it does. I'm going to grant the motion. Just as important too, if for whatever reason there are peculiar medical causation issues that prevent, say, a specific plaintiff from going to trial, we can peel them off. That's what we can do. But, and I do think, and I don't mind saying this, and I really respect Mr. O'Doul, I know he's not here, but there are issues regarding judicial economy, because we just can't have 15 cases go to trial. And I don't mind saying it. If I could, I'd just put them all and just go to trial and get them done, because these cases do have an impact on the judicial. Just as important too, they have impacts on my other cases. There's no question about that. And so, Mr. Kemp, I don't know if we're going in September. That's something you're going to have to convince me of. We're currently set for February. If there's issues regarding firm trial settings, that's fine. But you've tried cases in this department. You know what I do. I try to manage it in a way that is fair to everybody. You know that. Prepare the order. We're done, right? Yes, sir. And last but not least, this is what I'm going to do. I put in the order. I want a meeting with Mr. Hale within the next 2 weeks. Everybody goes there. And issues to be discussed, you probably know better than I do, but what do we do with the current case agenda, those types of things. And I mean, I don't know, but I think we need to go to him.
Yeah, Judge, I think we're there already on 328.
Okay, 328, this would be part of 328.
Yeah, could you give us 20 days to go to Mr. Hale in case I'm wrong about that?
Whenever the next setting for Mr. Hale,
Thank you.
that has to be an agenda item.
Okay,
How's that?
that's fine.
Everyone enjoy your day, and we're done.
You too, Your Honor.
Thank you, Your
Thank you so
Honor.
much.
Here.